Доброго ранку, шановні пані та панове.
Good morning, ladies and gentlemen. Welcome to Ukrainian Crisis Media Center. We are here to listen to the report by Ms. Matilda Bogner, the head of the Human Rights Monitoring Mission in Ukraine.
Good morning, everyone. Ladies and gentlemen, on behalf of the Human Rights Monitoring Mission in Ukraine, I would like to welcome those present here today and those joining us online. Today we are launching our 29th report, which covers the period from the 16th of November 2019 to the 15th of February 2020. The report covers key human rights developments and makes recommendations to relevant stakeholders. The findings we present are based on verified information collected from primary and secondary sources that are assessed as credible and reliable. For this report, we have gathered information from 129 in-depth interviews, as well as obtained information from relatives and victims and their lawyers, conducted 52 site visits, and monitored 118 court hearings. The reporting period was marked with the simultaneous release of detainees by the government of Ukraine and the self-proclaimed republics that took place on the 29th of December 2019. OHCHR was able to interview a number of the people released, and the report covers these findings, which I will present shortly. First, I will begin with our assessment of civilian casualties for the reporting period. From mid-November to mid-February, OHCHR recorded that 2 civilian men were killed and 17 civilians were injured, 13 men, 3 women and 1 boy. This is a 55% decrease in civilian casualties from the previous 3 months. 2019 had the lowest civilian casualty figures for the entire conflict period, with 27 killed and 140 injured, a 41% lower than in 2018, when 55 persons were killed and 226 were injured. Whatever the figures tell us, we know that in every single case there is human suffering. On the 18th of December 2019, a 57-year-old man was killed by sniper fire while sitting on a bench next to his house in government-controlled Marinka in the Donetsk region. He reportedly died on his way to hospital. On the 30th of January this year, a 68-year-old woman was injured by mortar shelling in armed group-controlled Donetsky, Lugansk region while at home. Mines and explosive remnants of war also continue to kill and injure civilians. Since the conflict started, the total death toll for civilians has reached at least 3,350, and more than 7,000 have been injured. Despite the progressive decrease in civilian casualties, the security situation in the conflict zone remains fragile. And indeed, we have seen several spikes in hostilities in January and February this year. The ceasefire continues to be violated on both sides of the contact line. OHCHR continues to urge the parties to strictly adhere to the unlimited ceasefire agreed by the Trilateral Contact Group in Minsk and to fully comply with international humanitarian law. 0 civilian casualties are possible if the parties take the appropriate steps. More positively, OHCHR welcomes the fact that Parliament continued to work on the draft law number 1115 on the status and social protection of civilians who suffered as a result of hostilities and armed conflict, and considers this an important step towards the establishment of a comprehensive national policy on remedy and reparation to civilian victims of the conflict. The armed conflict continues to negatively impact the economic and social rights of the civilian population. We were especially concerned by the decision not to adopt legislation delinking IDP registration with pension payments for those registered or residing in territory controlled by armed groups. The UN Committee on Economic, Social and Cultural Rights recently published its concluding observations following Ukraine's 7th periodic review and stressed that the government needs to ensure that residents of armed group-controlled territory receive their pension and payment of pension arrears. We urge the new government and Parliament to review the draft legislation on pensions in line with human rights standards and to bring it back for adoption as a priority. In a positive development, on the 28th of November, Cabinet of Ministers Resolution number 815 entered into force, simplifying crossing of the contact line by children below the age of 14, with only a birth certificate. OHCHR further welcomes the extension of this measure to children under 16 by the Ministry of Veterans, Temporary Occupied Territories and IDPs, and the State Border Guard Service of Ukraine until May 2020. However, the situation for children between the ages of 16 and 18 still needs to be resolved. During the reporting period, OHCHR further confirmed patterns of arbitrary detention, torture and ill-treatment, both in territory controlled by the government and in territory controlled by the self-proclaimed republics. In particular, following the simultaneous release of 29 December, we interviewed 56 of the 76 detainees that the self-proclaimed republics released and handed over to the government of Ukraine. Of the 124 detainees released by the government, we were unable to interview any by the cut-off date in the context of restrictions imposed on our operations in the self-proclaimed republics. However, we had previously interviewed 75 of them while they were in government-controlled territory. Since our report was prepared, we have also been able to interview a handful of these detainees in Donetsk and Lugansk. In the self-proclaimed republics, we found systematic practices of torture and ill-treatment of detainees. The frequency, intensity, and length of torture and ill-treatment varied considerably, but it usually continued until detainees agreed to self-incriminate themselves. Beatings, electric shocks, asphyxiation, mock executions, and sexual violence have been commonly used. In both the republics, it is the so-called ministries of state security who are responsible for these egregious violations. Torture in self-proclaimed Donetsk People's Republic often occurred at the infamous Izolatsiya detention facility. One former detainee said that he had begged his torturers to kill him as he could not bear the pain anymore. Another detainee said he tried to commit suicide after having been tortured because of the high level of pain. We also found a consistent pattern of arbitrary detention, often amounting to enforced disappearance, which created an environment in which torture could be perpetuated. This makes the issue of access for international monitors to detainees in the self-proclaimed republics even more urgent. In line with the understanding reached during the Paris summit of the Normandy 4 on the 9th of December to grant international organizations unimpeded access to places of detention in territory controlled by the self-proclaimed republics, we call for such access to be provided as soon as possible. In relation to the government-controlled territory, the 75 cases that we followed demonstrated patterns of torture and ill-treatment and arbitrary detention or procedural violations at the initial stages following arrest, holding persons in unofficial places of detention, mainly by the security service of Ukraine. 57 of the 75 individuals we interviewed reported being subjected to torture and ill-treatment, notably by the SBU. The interviewees described methods of torture which included beatings, asphyxiation, electric shocks, mock executions, and various threats. Though the prevalence of torture and ill-treatment and arbitrary detention decreased if compared to 2014 and 2015, they remain a serious concern. I would like to recall that the ban on torture and ill treatment is absolute, and that no circumstances may justify its use. I also recall that in the context of an armed conflict, torture and ill treatment may amount to war crimes and can be prosecuted under international criminal law. The simultaneous release also raised concerns regarding the administration of justice. Victims of human rights violations have rights to justice, truth, and redress. The release of individuals prosecuted for such violations may deprive victims of these rights. While we note that the simultaneous release of detainees is aimed at promoting peace and reconciliation, I would like to recall that it should be balanced with Ukraine's obligations to investigate and prosecute human rights violations and ensure victims' rights to an effective remedy. In territory controlled by the self-proclaimed republics, OHCHR is particularly concerned that the so-called courts widely relied on confessions obtained through torture and coercion. Individuals suspected of having committed conflict-related crimes in territory controlled by both self-proclaimed republics told OHCHR that they were systematically subjected to torture and would not dare to withdraw self-incriminating testimony during these so-called court proceedings for fear of being tortured again. It has been 6 years since the killing of 98 people during the Maidan protests and the violence in Odessa on the 2nd of May 2014 that led to 48 deaths. While there has been little progress in the investigations and prosecution of these deaths, we do note the recent development in the investigation of the killing of one protester on the 20th of February 2014. Almost 6 years after his death, the State Bureau of Investigation arrested a former internal troops officer on 18th of February for the killing. The following day, the court placed him under house arrest. A number of key legislative developments also occurred during the reporting period. OHCHR welcomes the adoption of the revised text of the Electoral Code on the 19th of December, which entered into force on the 1st of January 2020. It addresses long-standing recommendations made by OHCHR concerning the need to enfranchise IDPs and labour migrants in elections. However, we urge the Central Electoral Commission to develop a procedure to manage individual requests to change voting addresses to ensure that the right to vote is fully implemented in time for the local elections planned this autumn. The deadline of 16 January set by the law on state language for the drafting of the law on the realisation of the rights of Indigenous peoples and national minorities of Ukraine passed without any action. This law is essential to ensuring a fair balance between the legitimate aim of strengthening and promoting the Ukrainian language and sufficiently safeguarding language-related rights of national minorities. The UN Committee on Economic, Social and Cultural Rights further recommended Ukraine to expedite the adoption of a law on the realisation of the rights of Indigenous people and national minorities of Ukraine. Fundamental freedoms, such as freedom of expression and opinion, are, as the Human Rights Committee stated, indispensable conditions for the full development of the person. They constitute the foundation stone for every free and democratic society. However, while noting the effective policing of public assemblies, OHCHR documented 9 attacks against human rights defenders, journalists, and members of the LGBTI community. Despite some long-awaited progress in the case relating to the killing of Pavel Sheremet in 2016, accountability in this case and in a number of other past attacks is yet to be achieved. Regretfully, law enforcement officers present during attacks continue to fail to immediately stop violence as it occurs. During one of the hearings in the Sheremet case, 3 journalists, 2 women and a man, covering the trial were attacked and threatened. Law enforcement officers were present but did not intervene. OHCHR is also concerned about discriminatory attitudes within the police. In one case, the police simply refused to register the complaint of 2 women expelled from a bar for their supposed homosexual conduct until the women's lawyer applied to court, which ordered the police to register the case. This type of discrimination has no place in Ukraine. In Crimea, temporarily occupied by the Russian Federation, we continue to document violations of international human rights and international humanitarian law. During the reporting period, the Russian Federation completed its 10th conscription campaign since the beginning of occupation, enlisting at least 3,000 men from Crimea into the Russian armed forces. This brings the overall number of Crimean conscripts to at least 21,000 men. OHCHR identified 25 cases of draft evasion heard by courts in Crimea in 2019, with at least 7 found guilty. We recall that, under international humanitarian law, as an occupying power, the Russian Federation cannot force protected persons to serve in its armed or auxiliary forces. OHCHR was also concerned to note that Crimean courts ordered the deportation and forcible transfer of at least 191 individuals considered as foreigners under Russian law, including 109 Ukrainians. Once expelled, these individuals are frequently banned from entering the Russian Federation for up to 10 years, preventing them from returning to Crimea. This is also contrary to the Russian Federation's obligations under international humanitarian law, which prohibits transfers and deportations of protected persons from occupied territory. Looking forward, measures are being taken to develop the National Human Rights Action Plan for 2021 to 2025. This presents an opportunity to address long-standing human rights concerns. OHCHR is available to accompany the government as it undertakes this effort. In 2020, Ukraine will undergo a review of its progress in achieving the Sustainable Development Goals. This is an opportunity to review advances in human rights in the country. As the UN Secretary-General stated to the Human Rights Council last month, human rights are our ultimate tool to help societies grow in freedom. They expand the horizons of hope, enlarge the boundaries of the possible, and unleash the best of ourselves and our world. OHCHR has provided a number of recommendations in this report and in previous ones, which serve as a basis for enhancing human rights, peace, and development for all Ukrainians. We stand ready to continue supporting the efforts of the authorities in this agenda. Thank you.
Друзі, якщо маєте запитання до
Dear friends, if you've got any questions, please raise your hands, introduce yourselves, and ask your questions.
I have a couple of questions considering different topics, and I don't know whether it would be more convenient for you if I ask all of them at once or one by one.
I don't mind, whichever you prefer.
Okay, so the first one is about the people who live in the occupied territories and in the government-controlled territory. You said that you conducted in-depth interviews with them. How have you conveyed them that the information they give to the mission is something that that the mission can be trusted? How have you conveyed them in this case?
You mean how do we know that the information is credible?
Yep.
Yeah. Okay.
How did they understand that they can give you this information despite it may make them feel vulnerable?
Okay, yes. We have a monitoring methodology which we follow. Part of that is to ensure that we do no harm, that people who give us information will not be made more vulnerable because of that. We certainly explain to those whom we interview what our methodology is, how that information could be used, and then they give consent regarding how it could be used. We carry out a lot of interviews which do not get included into our reporting because people are not comfortable with that being included. So we only will include it if they want us to include it and give consent for that. We also do our own assessment as to whether us including that will make any harm for those giving us the interviews. You will notice in our reporting that we often don't, for the most part, we don't include names or identifying features. That is for the issues of do no harm. In terms of the credibility of the information that we receive, we do an assessment that, on reasonable grounds whether what we're being told is credible. We will use a variety of means to do that, including whether what we're being told is part of a larger pattern that is being described to us by other interlocutors, and we will also just assess the credibility on its own grounds. So the information that we include in reports is only the information that we have assessed to be credible and verified.
Thank you. And another question, considering law enforcement forces, have you made any count with the Security Service of Ukraine whether they have given any information about the tortures from the government-controlled side? This is question one about the Security Service and the count from their side. Have they given any information about whether these tortures are credible, or whether the Security Service does not confess in these tortures? And another one, has any evolution in the newly appointed ex-general prosecutor Ruslan Rябошапka and his team, have his changes in the prosecution ever touched the case of accountability about the tortures, about the Crimea cases, and about the possible about the fact that the law enforcement officers may not be okay with the human rights? Have you understood my question?
Perhaps partially. I can try to respond.
I can just try to repeat this in case. So, has the Security Service given you any information on whether they agree or disagree with your facts about tortures on the government-controlled territory? And has the reformed prosecution made any changes in cases that are connected to the tortures and tortures by law enforcement, and to any cases in Crimea, in the violation of human rights in Crimea? So has the new prosecution done any changes in these cases?
Okay. In relation to the SBU and whether they admit to involvement in ill treatment or torture on this side, we certainly meet with them. We raise concerns, we raise allegations with them, and we discuss that. They say that they will look into cases. We have not seen any concrete results coming from that at this stage. In relation to the prosecution, I know that their office has in recent months established a unit which is specially created to look into cases of human rights concerns related to the conflict. We see this as a good step. It's still a little bit early to see the actual concrete results of that at this stage. In relation to Crimea, they have long had a special section that does look into crimes in Crimea. We meet with them regularly. They have produced a report this year outlining some of the work that they do, and that work continues. But we haven't seen any specific change in that regard in recent times. So, okay.
The question is going to be in Ukrainian. So.
Okay.
Mr. Holokonian, so I have a question also. Dmitro Halakunian. I have also two questions. First question relates to pensions. Do I understand correctly that in your report it's defined that payment of pensions only in territories under government control for pensioners is a case of violation of human rights of civilians, and Ukraine should pay also pensions to those people who do not want or who can't leave uncontrolled territories of Ukraine to come to the government-controlled territories. And the second question, I didn't hear anything about violation of human rights of victims. I mean the second change of people when those who were already accused and detained. For example, in Kharkiv region in 2015, one teenager has been killed, and a perpetrator has been just charged for the whole life detention. And also those Berkut soldiers, that there was a final court decision, and they were also released from detention, and allegedly they would not return. So why in your reports there are no cases and there is no information about such cases, and those people, those perpetrators that are now released, they can't be brought to charges?
Okay, thank you for the question. I'm not sure that I got all of the second one, but I'll try to answer. In terms of the pension, yes, we consider that the government has an obligation to pay people on both sides of the contact line who have a right to pension. They need to pay that pension, and the failure of the government to do so is not in line with international human rights standards. They need to pay people the pensions. They need to pay them their arrears that are owed to them. In relation to the rights of victims, we do speak about that, and I mentioned it several times in the statement, and it is in more detail in our reports. Specifically, we did raise concerns around the Berkut releases, and that this would be a concern in terms of the rights of victims. I specifically spoke of the right of victims to truth and to justice and to accountability, and that is what these types of cases raises. It raises our concerns in that regard. I didn't really follow the issue around cases in Kharkov, but I hope that helps to answer that question. If you read the report in detail, there is information about that. We also put out a statement directly after the simultaneous release, raising our concerns about administration of justice issues, which is the way that we frame these issues.
Елена Бережная, директор.
Elena Berezhna, the Director of Institute of Social Protection, named after Elena Berezhna. First of all, I would like to thank you for such a report and for the whole work and operations of the monitoring commissions. I think it's one of the most objective and unbiased organizations that have been working in Ukraine since 2014. And thank you very much for your report, especially about discrimination of the education law and language law. But I have a question related to the duration of prosecutions of the cases dated to the Maidan situation. In each your report, you underline that there are no changes and improvements in prosecution of such cases, of such crimes. But do you think, or what is your position, that some perpetrators have been amnested and have been released due to the law on the 22nd of February 2014, and they said that you can't investigate and prosecute all cases related to the all cases of killings related to the law enforcement body specialists. But in other cases, those people that tried to protect the state and protect the people, they are under the charges and under the prosecution. I think this is a violation as minimum of the 4 provisions of different pacts and international agreements. But in your reports, in neither of your reports, there is no recommendation. And Venediktova, as an acting head of the bureau, has already raised this question. Maybe it's already time to give recommendations by the High Commissioner of Human Rights that you can't do any investigation if we have two parties, two perpetrators. We can't close our eyes on the one party and call them heroes, but to try to bring to charges another party, another perpetrator. But should we not give a justified rationale to these cases, to these different perpetrators? What is your position as a monitoring commission of violation of international pact in terms of violation of human rights, civil and social human rights?
In relation to Maidan, and actually more generally, we are always making a call that accountability is needed regardless of who the perpetrators are or who the victims are. If victims are seen as heroes, if perpetrators are seen as heroes, if victims are seen as having the wrong type of attitude, this isn't important. What is important is that there is accountability in all cases where violence has been perpetrated and where there are human rights concerns. So we always call for accountability in all cases. Specifically in Maidan, we have put attention on the fact that in the cases where law enforcement officers were the victims, there has not been accountability, and there needs to be, as with all of the other cases for Maidan. We have very much pointed this out. We have put out information on that, which is available. So.
Ще запитання, друзі.
One more question. If there are no more questions, thank you very much for your attention, and we will close our session. Thank you very much.